Thank you very much. Good morning, all. This meeting of the Honorable Senate for Friday, October 8th, 2021 is called to order. Statements by ministers. Announcements.
Laid on the table of the Senate today are the following. Ministry Paper number 66 of 2021 entitled Annual Report on Audited Financial Statement of the Jamaica Agricultural Society for the year ended March 31, 2018. Annual Report of the National Council on Education. Annual Report of the Broadcasting Corporation. And White Paper number 1 of 2021 entitled The National Policy for Senior Citizens.
Thank you very much. Bills brought from the Honorable House of Representatives.
The following is a message from the Speaker of the House of Representatives. To the Honorable Senate, I have the honor to advise the Honorable Senate that on the 6th day of October 2021, a bill entitled An Act to Amend the Companies Act was passed in the House of Representatives. Signed, Marissa Dalrymple Philibert, MP, CD, Speaker of the House of Representatives.
Mr. President, I signify my willingness to...
Can't hear you. Could you?
Mr. President, I signify my willingness to take charge of the bill.
Thank you very much, Minister.
A bill shortly entitled the Companies Amendment Act 2021 read a first time.
Mr. President, I beg to give notice of second reading of the bill.
Thank you, Minister. Petitions, papers, reports from committees, notices of motions given orally.
Mr. President.
Sorry.
Mr. President, I beg to give notice that at the next meeting of the Senate, I will move the Disabilities Act 2014, the Disabilities Regulations 2021 resolution. Whereas, by virtue of Section 46(1) of the Disabilities Act 2014, hereinafter referred to as the Act, the Minister may make regulations to give effect to the purposes of the Act, and whereas Section 46(3) of the Act provides that regulations made under the Act shall be subject to affirmative resolution, and whereas on the 21st day of July 2021, the Minister made the Disabilities Regulations 2021, now therefore be it resolved by this Honourable Senate as follows. 1. This resolution may be cited as a Disabilities Regulations 2021 resolution. 2. The Disabilities Regulations 2021, which were laid on the table of the Senate on the 8th day of October 2021, are hereby affirmed.
Thank you very much, Minister. Questions and answers to questions. Motions that may be made at the commencement of public business requiring notice. Motions relating to the sitting of the Senate. Motions for leave to introduce bills. The presentation of bills without the leave of the Senate first obtained. Public business. Minister.
Thank you, Mr. President. Oh, it's done. Mr. President, there are two items on the agenda today, two bills, and I rise to present them to this Honourable Senate, the Judicature Appellate Jurisdiction Amendment Bill 2021 and the Judicature Parish Courts Amendment Bill 2021. The fundamental importance of these bills before us is that they will grant, when passed, a limited right of appeal to the prosecution in criminal proceedings in both the Parish Court and the Supreme Court. More particularly, these bills seek to, 1, amend the law to grant the prosecution a right of appeal with the consent of the Director of Public Prosecutions where A, there has been a verdict of acquittal in an administration of justice offense, and so that circumstance can be understood. An administration of justice offense means the offense of A, perverting the court of justice, and B, the course of justice, and B, bribery or intimidation of or interference with a witness or judicial officer or a family member of a witness or judicial officer, and family member in this subparagraph includes a relative by marriage, a relative through adoption, and a spouse as defined in the Maintenance Act. Administration of justice offense also includes perjury. Mr. President, this right of appeal to the prosecution with the consent of the Director of Public Prosecutions will also apply to circumstances where there has been a verdict of acquittal based on a point of law that was erroneously upheld by the trial judge, and where the sentence handed down was unduly lenient or manifestly inadequate for the offense, having regard to any applicable sentencing guideline, or where the court did not have the power to pass the sentence. Mr. President, it will allow, or they will allow, the prosecutor to refer an acquittal to the Court of Appeal for their opinion on any point of law or any point of mixed law and fact under the Judicature Appellate Jurisdiction Act. And they will amend the Criminal Administration Act to provide an exception to the rule against autrefois, or the rule against double jeopardy, which would allow the prosecution, again with the consent of the DPP, to apply to the Court of Appeal to quash an acquittal and direct a retrial in limited circumstances. The bills will amend the Legal Aid Act to allow legal aid to be available to a respondent in any criminal appeal. They will provide certain procedural requirements that will accompany the limited right of appeal by the prosecution, and these include, among other things, time limits for when the prosecution may give notice of and serve an application for leave to appeal, and proffer indictments for retrial of the acquitted person. Mr. President, this Honourable Senate is asked to note that the definition of prosecutor for the purposes of these bills is also being expanded to take into consideration other individuals who may legally exercise prosecutorial powers. The definition of prosecutor will be A, the Director of Public Prosecutions or any of the attorneys at law employed in that office, or an attorney at law to whom the DPP has granted a fiat to prosecute the case. B, a clerk of the court. C, the Integrity Commission's Director of Corruption Prosecutions. D, the Director General of the Major Organized Crime and Anti-Corruption Agency, MOCA. And E, a person who has initiated a private prosecution. So all of these people don't become the DPP, for the record. They are prosecutors, not directors of public prosecution. Where we speak to consent of the DPP being required for an appeal to be brought under these bills, that consent is from the Office of the Director of Public Prosecutions. Mr. President, in the criminal justice system, the state, having regard to all its resources, has historically been viewed as having more power than an accused person, and consequently, the law has traditionally provided certain safeguards to protect the accused from this imbalance of power seen as in favor of the state. The safeguards include the presumption of innocence, the right to due process and a fair trial, the prosecution's burden of proof, and the right of appeal afforded to the accused against conviction. And none of these safeguards or protective mechanisms are being removed by the amendments before us today, Mr. President. They all remain a part of the criminal justice system. And I think it's important for us to make the point that significant protection will always remain in favor of the accused. Mr. President, the power imbalance of criminality, however, is seen around us and across the globe every day. It has shifted over time. Modern developments such as the intricate transnational nature of criminal organizations, the sophistication of local gangs and their access to extensive resources, and very importantly also, the technological advancements in forensic science, and in particular, the use of DNA evidence, have necessitated a review of some of the traditional rules. They produce circumstances where strict adherence to the traditional rules can now actually serve to undermine the integrity of the justice system, which must deliver justice. Justice. So, for example, Mr. President, where subsequent to an acquittal, fresh evidence becomes available in the form of a voluntary confession or DNA evidence, which points to the guilt of an acquitted person under current law, notwithstanding those circumstances, the prosecution cannot appeal against the acquittal, and one could not say that justice would be served. Imagine your family member is murdered, cold blood, but the case against the accused fails for a technical reason, even insufficient evidence. And DNA evidence is subsequently secured that proves that the accused committed the murder. And his attorney can simply say to him, "It's all right, boss, the prosecution can't do anything about it, case done, close." The prosecution can only say to the hard-working policeman or woman that found the evidence from their improved training and the forensic tools now being provided, all they can say is, "Boy, there's nothing we can do now, case done, close." And then they can only hold the hand of the victim's family and say, "We're really sorry." The interests of justice as a whole cannot be said to be served in these circumstances. This world of cold-hearted criminals that engage in shootouts with busy streets with no care for who gets hurt or killed while they go about their murderous activities for turf, no care that a beautiful 5-year-old like little Denique Salmon can be shot in her bed while sleeping, having what we would hope are the sweetest of dreams. No care about the trauma and fear that they inflict daily on innocent, hard-working people going about their business, trying to be productive citizens and providing for their families, trying to go to school, or worse, now focusing on online school where they have a device and there's gunshot firing outside. Mr. President, some things have to change. They have to change. And there are different pieces of the puzzle that require actions by the state, and the bills before us today are one small part of that puzzle. Mr. President, the prosecution also has no right of appeal against an acquittal that was obtained as a result of actions designed to pervert the course of justice. That is where criminals feel sufficiently empowered and emboldened to pay off witnesses and jurors, to threaten families into silence, to destroy material evidence so that a case cannot be successfully made against them, in circumstances where they could care less whether the state has the time or resources to try to pursue a case for perversion of justice if able, because they know that all they want to do is to make sure that their brethren, their bossy, them shut up, that they have gotten them off the murder charge. They know the prosecution, if the law stays as it is, can't appeal if the case fails, notwithstanding the gross miscarriage of justice it will deliver to the society, insofar as the good of society as a whole is concerned. And here I take the good of society as being one in which the safety and security of citizens are assured by the state. So I raise the interest of the victim here as well, Mr. President, whose only representation in the system is the prosecution. The amendments before us today will give them a voice. The victims, Mr. President, the amendments before us today can change that imbalance. Mr. President, I also remind that as the law stands, without these bills before us, the prosecution has no right of appeal, where a judge has misdirected the jury in his summing up, and which has led to an acquittal. Mr. President, senators may even have seen media reports, I recall, where a judge called a jury's verdict acquitting a pastor as disgraceful in light of what had been put before them. I mean, one can imagine the extreme circumstances that would have a judge address a jury in that manner. But the point being that there are circumstances which may require, in which it is justified for the prosecution to have a right of appeal in order to deliver justice. Mr. President, many of our Caribbean and Commonwealth neighbors have already passed legislation that allows the prosecution to have a limited right of appeal. They get it. They got it some time ago. Therefore, Mr. President, the amendments bring us in line with CARICOM and Commonwealth neighbors, including Barbados, Trinidad and Tobago, Bermuda, and in the UK, all of which have long recognized that the whole nature of criminality and justice has shifted across the globe, and that if systems don't shift to keep pace with the criminals and with the technology, then we stand to reap the consequences. And, Mr. President, just a brief reference to a particular case that occurred elsewhere, and persons who follow these matters may recall the 1993 stabbing of Stephen Lawrence, a youngster, a British citizen, but of Jamaican descent, who was stabbed by some racist white youth at a bus stop while he was simply waiting for his bus with his friend. Mr. President, charges were brought against accused persons and dropped. There were calls for inquests. The prosecution refused to take up the matter. The parents brought a private prosecution 3 years later, and it failed. So persons were acquitted. They were acquitted. They continued with loud public advocacy to call for inquests, which took place and which in fact exposed deep systemic racism within the police and prosecutorial systems. And in 2005, the UK scrapped the rule against double jeopardy. They scrapped it. And DNA evidence was found. DNA evidence was found which pointed to persons who had previously been accused and acquitted in that 1996 case. And only because that rule against double jeopardy had been removed, that family received justice. 2 of the 3 are still serving life sentences, although the case was brought way after. If you see, the double jeopardy rule was changed in 2005, and Stephen Lawrence was stabbed in 1993. And one could not say that in these circumstances justice was not served. Justice was served for Stephen Lawrence. And his case prompted a full realignment of how it is that the prosecutorial and security forces in Britain deal with cases where race is at the heart of them. So we have to have a broad view of these matters. Yes, there is a rule against double jeopardy, but our Constitution allows. Section 16(9) of the Constitution does allow for the right of prosecution, the rule against double jeopardy to be adjusted as it is now by the amendment of Clause 7 of the Criminal Justice Administration Act under this bill. So, Mr. President, the time has come. Time has come. This matter has been discussed for decades in the private and public bar. Consultations have been had not only with the prosecutorial members of the technical teams, but also with the private bar. They have made submissions, amendments have been made, significant efforts have been made to in fact present what would be the most balanced and just laws which are before us today for consideration. The time has come for Jamaica to amend its laws and provide prosecutors with a right of appeal. Mr. President, I just wish to highlight a few main features of the bill, indeed the bills. Clause 2 in both bills introduces new terms and their subsequent definitions. I've already dealt with the administration of justice offence, and we are all aware of the circumstances where in small inner-city communities the ability of gangs to quote-unquote reach out and touch and to intimidate cause many a prosecution to be challenged. The administration of justice offence is necessary, and it is here in the bills before us. Mr. President, the definition of prosecutor has also been expanded, as I mentioned earlier. Clause 2 will also empower the prosecutor to appeal against a decision of a judge of the Supreme Court or parish court on any point of law. So one of the issues that had come up when this was first being discussed was whether they could also appeal on points of fact. And it was agreed that this would perhaps be a bridge too far, and it is not in the bills before us. It has been amended, I believe, before the bill was even tabled in the lower house. So a prosecutor can appeal against a judge of a Supreme Court or parish court on any point of law or on the ground that there has been an administration of justice offence in instances where the decision results in an acquittal or another form of termination of the case. The clause also empowers the prosecutor to appeal against any sentence imposed by the Supreme Court or parish court on the basis that the court did not have the power to impose the sentence, or that the sentence imposed was manifestly inadequate or unduly lenient, unless the sentence imposed was the maximum allowed under the law. And we have all heard, Mr. President, the public is aware, Mr. President, when cases are handed down and sentences are handed down, rather, that the public cannot understand as being manifestly just. And the more that happens is the more the public loses faith in the justice system. These are the things that give impetus and strength to vigilante justice, because they feel, why bother? Because you can't, if the system is not going to deliver justice, then why not take justice into your own hands? So, Mr. President, when those issues are raised, people say, well, you're in the Parliament. You have the power to change laws. And they are right. So within the strictures of the Constitution, change the laws, we must. And that is what we have before us today. Mr. President, the clause continues to set out the procedural requirements in filing the appeal and the process upon the appeal being filed. So this is not something that is at large, without any safeguards, without any processes, and without any limitations. It's actually quite constraining and quite difficult, but it has been felt to be the best balance possible in the circumstances and at this time. So, Mr. President, once the Court of Appeal has heard the appeal with respect to any point of law or on the ground that there's been an administration of justice offence, for example, the court is empowered to quash the decision made by the trial judge and substitute an appropriate decision or affirm the decision and dismiss the appeal. So it is not a guarantee that because the prosecution is going to appeal that they will succeed, but that they have the right to, Mr. President, gives the victim a voice and not just circumstances where they are told, we're sorry. Mr. President, the Court of Appeal has the same power regarding sentences appeal, that is, to either quash the sentence imposed by the trial court and substitute an appropriate sentence or affirm the sentence handed down at trial. So all these options remain available, and in all these circumstances, Mr. President, the consent of the DPP is required to make the appeal. Mr. President, importantly, the clause stipulates that a 12-month period from the date of application or from the date on which the appeal was brought in which these appeals must be heard. So it's not totally at large, which could be a concern depending on your perspective. But additionally, Mr. President, in instances where the court orders a retrial, the retrial must commence within 6 months after the date on which the order was made. Mr. President, under the Appellate Jurisdiction Amendment Bill in particular, Clause 3 amends Section 19 of the Principal Act to expand the right of appeal to expressly include the prosecutor. And then Clause 4 amends Section 21 of the Principal Act to allow an appeal to be made relating to a person's conviction or on any of the other grounds previously mentioned. And Clause 5 allows the prosecutor to refer an acquittal to the Court of Appeal for their opinion on any point of law or any point of mixed law and fact where the accused was tried on indictment or information by virtue of a special statutory summary jurisdiction. So, Mr. President, the clause will allow the prosecutor to refer this point of law or mixed fact and law where an accused has been discharged on the grounds that there's no case to answer, where proceedings have been stayed, or a ruling that has been issued to terminate the trial. And in these circumstances, the court is required to consider the point and provide its opinion, but it will not affect the trial or the acquittal. These circumstances are around building the jurisprudence and clarifying what the law is in the circumstances. So, Mr. President, in these circumstances, the Court of Appeal will provide guidance and jurisprudence on the particular area of law. Mr. President, Clause 6, the final clause of the bill, seeks to consequentially amend other pieces of legislation. So the clause amends the Legal Aid Act to allow legal aid to be available to a respondent in criminal appeals by the prosecutor. And the clause goes on to amend the Criminal Justice Administration Act, as I referred to earlier, to provide an exception to the rule on autrefois acquis, or the rule against double jeopardy. So it doesn't remove it, it just amends it. This would allow the DPP or another prosecutor, as so defined, with the consent of the DPP, to apply to the Court of Appeal to quash an acquittal and direct a retrial in limited circumstances. That is, where there's new evidence, and I gave an example earlier about how new evidence can in real circumstances deliver justice, and it must be, however, that the new evidence, and this is set out in the Act, in the bill, new evidence, where the new evidence is compelling and where it is in the interest of justice for the case to be retried. The retrial would only apply to circumstances where a person has been acquitted of an offence in proceedings on an indictment or information by virtue of a special statutory summary jurisdiction of a judge of the parish court or on appeal against a conviction. Mr. President, under the Judicature Parish Courts Amendment Bill, Clause 3 provides a revamping of Sections 293 to 305 of the Act so as to provide a more coherent and cohesive ordering of the sections. And those are taken in addition to the earlier amendments which I spoke about in Clause 2. Mr. President, this ends the clause-by-clause summary of the bills before you, and I commend these bills to the members of the Senate for their consideration and approval. Mr. President, I thank you.
Thank you, Mr. President. Let me say at the outset how traumatic it was to hear of the killing of young Danique Salmon a little girl who was sleeping in her bed, her tablet fully charged in preparation for school the next day. Some vicious, cold-blooded murderers who were just on a rampage took her life, firing bullets indiscriminately, not caring who they hurt. And another young life snuffed out. Mr. President, you'll forgive me my slight departure when I say that we now have to treat these acts in very much as we are treating our vaccination efforts, the blitz, the encouragement to persons to take the vaccine. Because some way has to be found to mobilize a community against criminals and against criminal acts. The only way that we are going to assist in alleviating this is to make everybody realize that they have a part to play and that nobody is safe until we play our part.
Absolutely.
But this bill, which we are debating today, Mr. President, is really not about that.
Yeah, very important.
That kind of action requires that the significant resources which the Ministry of National Security has at its disposal and the Ministry of Justice has at its disposal must be used in a particular and targeted way. Senator Matthew Samuda made an excellent speech, a bit long, but an excellent speech, which had a lot and gave us material which we can use as references. He made the point that it is the first time that the Ministry of National Security has been allocated so much money, and I think it was about 90 billion. I think it is important for us to understand that you cannot have a conviction in the courts unless the investigators present a case which is tight, where the evidence is strong, and where it is clear, there's a clear direction as to guilt.
Yes, ma'am.
That, Mr. President, is what this country requires.
That's right.
It would be interesting to note that most of what they call the convictions in the courts come through guilty pleas and not through actual trials. Indeed, when we were discussing what we call the anti-gang law, we know that there could be a boast about it because the persons had pleaded guilty to the offense. So I asked myself, what has prompted this move? Why is it that we are at this place now? And if we are at a place where we are eroding some fundamental principles of criminal law designed to protect someone who is charged with an offense, then surely we deserve an explanation, apart from the Stephen Lawrence case.
In the UK.
Because there's absolutely no data to suggest that we have administration of justice cases which have not been pursued. There is absolutely no data to suggest that we have had acquittals on no case submissions or that indictments have been quashed. There is no data which has been presented to us. And if the data exists, it has been a well-kept secret.
Argument.
When you are changing these principles, Mr. President, it is my view that the widest possible dialogue should take place. And I hear what is said about the number of submissions which were received. I do know submissions were received which were not shared. I cannot see from the submissions which I received where it was taken into account. The only change which I saw was in relation to the mixed facts and law. And surely that was so out of line in terms of how the judiciary, how judges function. Because judges would have an opportunity to determine the facts of the case, which the Court of Appeal could not possibly have. And facts of the case, Mr. President, as you would know, are not just a man walking from A to B, but facts of the case involve how the witness communicates what he's saying, which the judge has the opportunity of seeing. And the judge, in his summing up, when it's a jury case, will say, notice the demeanor of the witness.
That's right.
This is a matter, in my view, these two bills, which should have gone to a joint select committee, and which would have benefited in the same way the Sexual Harassment Act, which we debated last week, would have benefited from the contributions of the public. Because in this part of legislation, do not make any assumption that anybody, even in Parliament, cannot be affected by it. We have seen in this country how when there are powerful and influential persons who have unlimited resources, the rights of the accused can be undermined. And I pause to remind you of one case which attracted public interest, and that was a case of which we refer to as the Gore-Stew case. A case which was prosecuted by an attorney who got a fiat from the Director of Public Prosecutions. These people were placed before the court. And as it turned out, because they had distributed pension funds, there was no suggestion that they had appropriated the pension funds for their own purposes. So in common parlance, it's not thief them, thief it. They went through a trial, and no case submission was made. The judge upheld the no case submission. And then that is when everything started. Because the attorney representing Gore-Stew applied for judicial review. And when he did not get it, he made a second application for judicial review. And he still didn't get it. So he went to the Court of Appeal. And the Court of Appeal did not give him leave. This case stopped at the level of the Privy Council because it couldn't go any further. It reached a stage where the judge was a party to the action. And luckily, in her case, the Attorney General came to her assistance. One of the commentaries made about it is to say that the matter failed because there was no right for a prosecutor to appeal. You who are in favor of this legislation must ask yourselves, what if that was me? Because these were prominent and highly respected members of the community, of the business community. These were persons who the Gorstew had formerly held in high esteem. And you must know that it is felt that they were hounded to their death. At least one person, let me be clear. That he died, one of those persons, people who know him well, knew that he died of a broken heart. Because he could not take the fact that his integrity had been questioned in this way and he was being hauled before the court as an innocent man. And that comes. You see, Mr. President, when the Director of Public Prosecutions or the Crown Counsel or the clerk rises, one of their favorite phrases is, I am a minister of justice. Yes, yes. I am on no one side. I am only for the pursuit of justice. And I want to tell you about another case before I get into the bill. I'm not going to ignore the bill. But I want to remind you of a case that took place in Irwin. Irwin in St. James.
Charlie.
Five women were taken out of their homes and raped in an open lot. The society was up in arms, and that was the right thing. Everybody was up in arms. The Prime Minister at the time was the Most Honorable Portia Simpson Miller, and she was enraged by the act. Society was enraged. Two young men, two brothers, were charged with the offense. They submitted to DNA tests, submitted voluntarily. They said, it's not us, take our DNA. And it turned out that the DNA did not match. You would have thought that was the end of it if you're a Minister of Justice, Senator Sinclair. You would have thought. But no. The Director of Public Prosecutions determined to continue with the matter. Determined to continue with the matter in spite of that. In spite of the fact that the very thing that we are speaking about with new, fresh, and compelling evidence, forensic evidence which assists us in making determinations, that was utilized in that case. That was utilized in that case, but it made no difference to the accused men. No difference. They were actually acquitted because the witnesses could not identify them. So when we talk about justice, there are some who make it seem that once you go before the court, you're a criminal. Yes. And you deserve the worst punishment in the world. That's the presentation that was made this morning. That is how people look at it and think it's only the victim. But I tell you, that in a criminal case there can be many victims. That's right. I practice in those criminal courts, especially in Clarendon, as one of the, at that time, one of the few women who went to the criminal courts. And I can tell you about injustice in the courtroom. Yes. It's not a fact that because you're before the court you have committed a crime. And many of us as defense attorneys might not be a Perry Mason type of person, but we have the skills to probe it and to bring truth to light. So, I asked myself about, let me start now with the amendment 18A. And this is very interesting to me, Mr. President, because it speaks to an administration of justice offense. And sometimes I ask myself, how easy is that to prove? How do you go about establishing an administration of justice offense? And it's very curious that I had a case. I was doing a murder case in the Clarendon Circuit Court. And during the lunch on adjournment, my client's mother signaled to me, and my instincts told me this was not something that I should deal with on my own. So I called Crown Counsel. And I said, Crown Counsel, would you just mind just hearing this with me? My client seems very agitated. And it was because a juror had approached her, the foreman of the jury, who was a woman. And she had been approached to say that if they got $150,000, the client would be acquitted. The Crown Counsel and I were totally taken aback by this. And we went into the judge's chambers. It was, at the time, Justice Sykes. And we communicated it to him. In the interim, the police had set up a sting operation because they had questioned the mother and found out that it was supposed to be, the exchange was supposed to take place at Juicy Beef. And they went there and set up a sting. So while we were in the judges, I thought you only read about these things in books, you know. So while we were in the judges' chambers, the police knock on the door and they have not one juror but two. Two jurors had agreed to take money to set the accused free. Now, I don't know if they would really have done it. I don't know if it was a scam. But one was horrified to learn that justice had been so perverted. So, bribery or intimidation of or interference with a witness, juror, or judicial officer. And I go now to a little concern about the definition of judicial officer. Because a judicial officer is, apart from the persons listed, a judge of the Supreme Court or Court of Appeal, a master of the Supreme Court, the registrar of the Court of Appeal, Supreme Court or Revenue Court, a deputy registrar of the Court of Appeal, Supreme Court or Revenue Court, a judge of a parish court, or a prosecutor.
Judicial officer, no? Prosecutor?
But when you go to the definition of prosecutor, and it lists all the different entities, there are many entities now which have been given the right to prosecute. Yeah. So, you know, you have several categories of persons who are referred to as prosecutor. But if you look at E, a person who has initiated a private prosecution of the case becomes a prosecutor. And by virtue of becoming a prosecutor, becomes a judicial officer. I would like to have an explanation, Madam Minister, as to what was the thinking behind making that person a judicial officer.
And that's different from arguments.
The Act makes provision for an appeal on a point of law on the ground that there has been an administration of justice where the decision results in an acquittal the quashing or stay of an indictment, the withdrawal of a case from a jury, the upholding of a no-case submission, or any other termination of the case without a verdict or conviction. But it goes on to say also that the sentence imposed by the Supreme Court on conviction, where the Supreme Court did not have the power to impose the sentence, or the sentence imposed is manifestly inadequate or unduly lenient. And now this curious addition, unless the sentence imposes the maximum sentence permitted under the applicable laws. You know, when I read that, I said, what exactly is the administration trying to do? Are they trying to interfere with the judiciary and judicial discretion? Because what this clause is saying, it's fine. It's fine. If you gave them the maximum which we have decided on, then it's fine. So unless the sentence imposed is a maximum sentence permitted under the applicable laws. Mr. President, I was critical of the fine of $200,000 for not wearing a mask. Yeah. And there is no time when persons might not take issue with sentences imposed. When I am asked, however, by somebody, a young attorney, and they get inflamed, I said, my dear, the law is nuanced, very nuanced. And the judge might have been privy to particular information which could have influenced the outcome of the sentence. And I was in a forum, and it's not the first time, where ministers of government have been critical of sentences which have been imposed. And I think I breach no confidence when I can tell you that the Chief Justice had to do a mini tutorial. He explained, for example, that somebody might be charged with illegal possession of firearm. There's a man and a woman walking down the street. The woman has a gun. Based on the circumstances, it is clear that it's a man's gun, and he has given the woman to carry the gun because he knows that the possibility of the gun being detected on her person is unlikely. Because, you know, you would have to have a female officer present and so on to carry out a search and so on. So he takes that risk because he's good at what he does. It emerges from the evidence that she acted under duress, that she feared for her life. The evidence, the defense is not clear-cut, but it is obvious from the evidence. And he asked the question, does she deserve the same sentence as the man who gave her the gun? And there are many, many such circumstances. I do not wish to confess, but I shall. That when somebody asks me, so why would a judge in the same court charge somebody $10,000 for not wearing a mask and charge somebody $200,000? I said, well, you know, circumstances matter to a judge. And if the person was in a situation where they said, oh, I'm so sorry, I left my mask inside, a judge might be inclined to be lenient. Whereas if the person says, tell the police every known word of abuse, tell them, sir, I don't believe in wearing mask, and I not wear no mask, and I will never wear a mask, go away with your policy. A judge, on hearing that, might be inclined to be very punitive. So there are all sorts of circumstances which could affect that decision. I want to also speak to where the appeal is made and the person is acquitted but was serving a sentence, was in custody, or where the sentence is said, as we are discussing now, to be too lenient. And I want to say, what happens to the person in the meantime? There is no provision here for bail being granted. He's serving a sentence. If he appeals, if the prosecutor appeals, does the sentence stop running? Does it operate in the same way like if he appeals? Is it something he has been sentenced, it is true, but what are the consequences? What are the consequences of that he bears if there's an appeal? And if he has been acquitted, but he was in custody, and the prosecutor signals to the court that she intends, and I say she advisedly, that she intends to appeal, does the judge allow him bail? Remember, it's an acquittal, you know. He has been found not guilty by the tribunal, but the prosecutor decides to appeal. What happens to that person? What happens to that person in the meantime? Because we know the process by which the transcript, how long the transcripts take to be ready. We know that there are cases in the Court of Appeal which have been outstanding for 3 years and 5 years. We know that there are in fact even appeals where people get lost, where the proper process has not been adhered to, and people don't even know, neither the correctional services or the court is aware that an appeal has been filed. And the man served, this was a recent case, served his sentence, put the Court of Appeal in a dilemma because they couldn't quite figure out at the start how to fix this matter. So these are questions which I would like to be just explained or amplified. There is also one other section that I could not understand, and that is 7 at 7.4, where there is a section which speaks to the fact that it is irrelevant whether the evidence would have been admissible in earlier proceedings against the defendant. Well, I couldn't understand the relevance of it. And I too, on that point, I would like to understand what was being achieved there by making that provision. And finally, Mr. President, lest I have to ask for an extension of my time, which I've never done.
And we are prepared to give it.
It's not you give me now. I'm sorry, Mr. President. Oh, the clause that I just referred to is at page 12, and it speaks about the new and compelling evidence, so that the new and compelling evidence would be allowed if it was not adduced in the proceedings in which the defendant was acquitted, nor if those were appeals there were appeal proceedings in earlier proceedings to which the appeal related, it is reliable, it is substantial, and in the context of the issues in dispute in the proceedings, it appears highly probative of the case against the defendant. And then it goes on to say, and for the purposes of this section, it is irrelevant whether the evidence would have been admissible in earlier proceedings against the defendant, because one understands that with fresh evidence, there are certain rules now for the person convicted that they have to comply with. And these, they are very similar to here. It has to be fresh, it has to be new, it has to be compelling, it could not have been available at the trial, and so on. It has to be reliable, it has to be substantial. In other words, it has to be very compelling to any tribunal. So the question of whether it would have been, it's irrelevant as to whether it would have been admissible previously. Cannot be an issue. Because the fact of the matter is that it was not available. It was not there. So why now go on this position where you have to qualify it when you are saying it is new, fresh, compelling, and all of that? I did not understand why that section would be there. And now, Mr. President, this vexed issue of legal aid.
Legal aid.
Legal aid. Oh dear.
Mr. President, the Speaker's time having expired, might it be extended to permit her to complete her presentation?
Aye. 10 more.
Mr. President, I deeply regret that I have to break a promise that I made to myself. And okay. So legal aid has been in the news quite a bit. And what has thrust it in the limelight now is that Klansman gang case, which is estimated that it will last at least a year. And based on the number of adjournments which have taken place so far, I would say 2 years. There are a number of accused. I think it is 26 accused before the court. And there are, of course, a number of attorneys. Mr. President, I was taken completely by surprise when I found out that the lead attorneys really will be making a little bit over $100,000 per month. And I commend them. I commend them for the service to their country. I commend them for their service to the justice system. I commend them for taking up this case, because I don't think it can put gas in their car for every day. I don't think it can photocopy all the material that they need to have. I don't think it can pay for any assistance which they might need outside of it. And I think for now, to bring legal aid into this, you're going to have to look at, Minister, looking at the legal aid act and the fees which are paid. Because I'm telling you, it's not easy out there. It's not easy being in practice. And to give up your time like that is really because of the commitment which you feel to just seeing that justice must be done. It is based on those hallowed traditions that we are speaking about today as changing. It is based on the presumption of innocence of an accused person. It is based on the principle that a man should not be tried twice for the same offense. It is based on a principle that counsel has a duty duty to offer his or her services when needed. And there are a lot of us, you know, when I used to do legal aid, I didn't even bother to send in a bill because it took me more time to prepare the bill than what I would get. So it would just be a formal assignment, but I would really be amicus, a friend of the court. So, Mr. President, you know, normally when I get up, and the minister knows this, I will say, this country passed this act in such and such a year, and we are just doing it. This country passed this legislation in order to sign a treaty in such and such a year, and we are just doing it. And I complain about it. This time I take a strong departure from that. And I say, on what basis are you asking for this?
On what basis?
And do you realize, has it occurred to you, that when you put in a right of appeal against a sentence in particular, and say that the sentence is manifestly inadequate or unduly lenient, that what you're doing is bringing the judiciary into question?
Yes.
That what you're doing is telling the public
That
you have no confidence in the judge's utilization of their discretion. That you have a justice training center.
What about the separation of powers?
But you have no confidence in what the training is. That you are willing to tread or trample on the whole concept of the separation of powers. That you really do want to dictate to the judges how they should sentence. That you want to stay outside the courtroom as legislators and determine what the sentence must be regardless of the nuances around the offense. So what signal are you sending to the public? What signal is being sent to the public about how you feel about the judiciary? The competence of the judiciary. The ability for the judiciary to use the sentencing guidelines which have been developed over the years to find an appropriate sentence. What questions have been asked where the sentence appears to be lenient? Since we are all supposed to be responsible persons, what questions do you try to find out about the case? Do you try to find out the facts of the case to see if there is a justification? Do you trust that a judge, hearing the facts, would have the training, the common sense, the judicial mind to be able to determine what is an appropriate sentence? Or are you saying to the public that you don't believe they're doing the job you want them to do? So the only reason, the only basis on which they can't appeal sentence is that if they are given the maximum which you have determined that they should get. And here we pass laws and we practically just start the fines at up to $1 million. It's like up to $1 million is embedded in our heads. Because we believe that the more you find somebody is the less likely they are to commit an offense. And I will tell you this, the true deterrent to a person who thinks about committing an offense is whether they are going to be caught and convicted. And when they see people being caught and convicted, they will then begin to fear. But when the murderers commit the murders and they are out there and they can go home the night and drink a bottle of Hennessy, or as they say, smoke up some weed and forget it, they will do it again tomorrow. But if we had kind of investigative capacity to be able to apprehend them and convict them, I tell you, we would begin to see some changes in this country. And so, Mr. President, I commend that we look at the mischief we are trying to solve.
Yes.
Because that is what we must always do. What is the mischief?
But you're still trying to understand. Bad crime. That's mischief.
If we want guilty persons to pay their price, let us examine what are the shortcomings now, why they walk free from the courtroom.
That's how you
Because a judge can't find them guilty if the evidence is not there. There is still a presumption of innocence. And those who would want to remove it, just remember, think about if you are the person in the dock. If it pleases you, Mr. President.
Thank you very much, Senator Scott Motley. Senator Sinclair.
Thank you, Mr. President. Mr. President, I heard sort of us coming from across the floor when my friend Senator Scott Motley indicated that she would not want to seek an extension of time. And somebody said, well, it's her birthday. I want to wish her a happy birthday. And as
Senator Sinclair, Senator Sinclair, were I not instructed not to put her birthday in the public domain, I would have done so. But since you have put hers in the domain, I would put yours in the domain and wish you a happy birthday.
And as we are putting birthdays out in the public domain, because October people are good people, the leader of government business is also an October boy. But my friend made some comments which I will seek to respond to quickly. She referred to the Irwin case out of St. James. Traumatic. In fact, it shook a lot of persons, well, right across the island. And in fact, the Minister of National Security at the time took leave of his office, took leave of Kingston, and traveled to Montego Bay. I suppose if we check the records, we will determine who was the Minister of National Security at the time. And I attended, I'm not calling any names. There was a meeting in Sam Sharp Square at which the minister spoke. What? And I was there, so I'm not talking from hearsay. And it was said at that forum that persons would be brought down, the investigators would be brought down from Kingston. And in fact, they displaced the local investigators because some persons believe that what comes from town is better than what is in the country.
I wonder if the minister tell them that.
But the comment was also made at that forum that somebody must be charged before the end of the week.
No.
The case was not only about DNA. I didn't speak at Sam Sharp Square. I only listened. I was in opposition. We were never given a platform.
You spoke, you would have been locked up.
By the end of the day.
By the end of the day.
But there was identification because the persons were charged because the witnesses went to an identification parade. And so the prosecution, in fact, I followed the matter when it went into the court to see what the outcome would be, because then you had eyewitnesses saying, I saw this person and I identified the person at the ID parade. And you had, on the other hand, the DNA evidence. What would a prosecutor do? They have to put up the evidence. They have to put up the evidence. Otherwise, they would be, as prosecutors, having a witness say, that is the person who I saw. And you were to say, no, you didn't see that person because there is the DNA evidence. That is the defense duty. The defense will use it to the advantage. It was disclosed to them. And so the evidence was put up and the determination was made in the appropriate way. When you have evidence like that in a criminal trial, the prosecutor is going to put it up for the tribunal of fact to determine the outcome of the matter. So that basically was what transpired here. I listened also to you, my friend, where you spoke about these bills as if they were coming now, they had their origin now, and to seek to give an impression that it was in this administration or since 2016
Hear this now.
that yes, that is what was being said. And you know, Mr. President, I've used it. I try most times not to be antagonistic when I come to these chambers. No, I try my best not to be. But you see, when I listen to comments that come from across the, sometimes it's best. In fact, a former prime minister says silence is golden. It's not everything you have to say. But don't be hypocritical in the process, man. Don't be hypocritical. Because and you know, in doing some research, I went further where I came across a letter which was submitted to the Gleaner. And it was over the name of Mark Golding, leader of the opposition, president of the People's National Party. In the Gleaner dated June 8th, 2021. And what was written there says, there was no draft legislation that was produced at that time, making reference to the administration of the People's National Party prior to 2016. The leader of the opposition said in the letter, and I quote, he says, 2 submissions to Cabinet seeking authorization to develop legislation to give a limited right of appeal to the prosecution against sentence and against acquittal in specific and limited circumstances.
What?
The leader of the opposition wrote that. And as I said, when you take that and put it alongside the comments made by Senator Scott Motley, referring to the now, as I said, as if these bills had their origin, thought, conceptualized at this time. I found it a little unfortunate. And you know, in fact, Mark Golding, in the lower house, when these bills were presented there, did say,
talk up a little louder, child. I want to hear.
Did say these words in reference to the bills, both bills that we have before us today. Madam Speaker, these bills provide more prosecutors to have rights of appeal in certain circumstances, and broadly they have my support insofar as they deal with specific issues which, when we were in government, I had initiated as Minister of Justice at the time. I take it further because I got a document. Yes. I got a document. Yes. And the document, Mr. President, is headed a bill entitled An Act to Amend the Judicial Resident Magistrates Courts Act. And at the top of it, I see the date, February 19, 2016. The election was the 25th of February, 2016. But it is in the form of a bill. And when I look at the document, I see the name Mark Golding, Minister of Justice, written there.
Really?
So we had gone beyond just a submission, because there was a bill was drafted, and the only thing that precluded it going further was the 25th of February 2016. 25th of February 2016. Right? So, Mr. President, this was conceptualized some time ago. You know, Mr. President, these bills are somewhat sensitive, and I heard the comments from my friend. I've spoken to attorneys, and it's sensitive. Some tell you they're just not for it at all. And you will have others who will say to you, and I've said, and there are attorneys too, who say that they have no problem with it, in principle. And you will have those who will take the position that with a few amendments, tweaking, it is something that can work. Mr. President, as was outlined in the opening by the leader of government business, and I'm of that view that justice has two sides. You have the accused and you have the victim. But we tend not to focus on the victim, because in a criminal matter, you don't hear it being John Brown against the accused. It is the state against the accused. But behind that reference to the state is an individual. Is an individual. And I always say justice sometimes, as I said, justice has two sides. The justice of a case may be that somebody must get 40 years in prison. That may be the justice of the case. And the justice of the case may be that a person should walk free. So that's how I view it. And when we have situations like that, when we have situations like that, Mr. President,
Charles, you have to make sure it's okay.
the accused has the right to appeal, and he can appeal to different levels, right up to the Privy Council. The victim just, for whatever reason, and the leader spoke to it, there may be things that have been described as administration of justice offenses. But the victim would just have to suck that up and go away, and that's the end of the matter. And he feels hurt. His family feels hurt in the event that there may have been a murder. What does that person do in order to achieve justice? Dear justice may be, no, let me take it to the street. And you may find situations arising that leads to other criminal offenses. Maybe. So, in principle, if you have situations that arise, I can't see why we should be against the principle of the prosecutor, the state that represents the victim having a right to appeal once there are constraints to it. Mr. President, I wish to applaud Minister Delroy Chuck and the policymakers in this matter for listening to the stakeholders. Because the first document that I got that represented the bill had some provisions in there that I did not feel comfortable with. I never felt comfortable with it. And you spoke to one of them where you asked about the bail. What would be the position of the accused? Would he be in custody, or as the case may be? The original draft spoke to the person being in custody unless they got bail under the condition, the circumstances stated in the Bail Act, etc. That is not in this bill because of discussion, dialogue with critical stakeholders in the process. What was in the original draft in that regard has been removed. And you raise a question, if the person is acquitted, and that's it. The person is acquitted, and is a free man, and is not constrained by any circumstance. It's not in the bill saying that he's in any way constrained. And so I believe that having been removed, commendable on the part of the minister and the policymakers in that regard. Mr. President, I also take note of the time frame within which an appeal shall be heard, as well as a retrial if the court quashes the acquittal at first instance. And there are specific timelines that have been set out. 12 months in respect to the appeal, and 6 months in respect to the commencement of the retrial. Because in criminal matters, there have to be some closure. And what that is saying to the state is that you better make certain. So, I think it is in 18A, and you have the clauses, but the clause is inserting an 18A. So it's 18A, subsection 9, that speaks to the 12 months in respect to the appeal, and in respect to the retrial, there is a 6-month period for the commencement. Now, right, so there are time frames. Criminal matters have to have some ending to it. And I was happy when I saw that put into the present bill because it was not contained in the original draft which I saw. And so, Mr. President, the minister listened, he heard the comments, from the attorneys and others, and attorneys of high profile who would have had concerns, and amendments were made. In fact, there were some significant amendments which was made from the original draft, in excess of 12 coming from the lower house. And so, as I said, I come in. As I said, it places a burden upon the state in that regard, because the provision that speaks to time constraints will demand greater efficiency in the court system. There will be need for stenographers who are trained and who are motivated, and equipment that can translate voice to readable print so that transcripts are available in the shortest possible time. So I'm just saying this, and I have other comments that I am going to make, that we're putting in a legislation that speaks to time, issues of time, but the state must be aware that there are other things that will have to be done in order to ensure that the time constraints that you set out here can be met if we're speaking about the justice of the case. Because the justice of the case may be that the person would be retried and the appropriate findings are arrived at. But let us say that you don't put in the other measures to ensure that you can meet the deadlines. Then the person walks again, and the justice of the case is not met. So the state must bear that in mind, that there's need for other things. And the Minister Chuck, he has made comments in respect to first instance matters, that he doesn't want criminal matters just dragging through the court for any extended period of time. He's of the belief, and he has said it publicly, that criminal matters before the court where accused lives are put on hold, they are suffering through this situation with reporting conditions and other conditions that may be imposed on them if they are on bail or if they are in custody, that these matters must be dealt with in a timely fashion, and so that persons can get back to their lives and there is some finality to the situation. Mr. President, the inclusion in the bill of provisions that allows for references and points of law or mixed law and fact is something that resonates well with me and should go a far way in building on our local jurisprudence. And an issue came up as to whether we should abandon appeals to the Privy Council and go to the CCJ or otherwise. I think it was former Senator Alexander Williams who said if we build our jurisprudence and we have judges of the kind that we have produced in this country, our Court of Appeal can possibly be the final Court of Appeal. So we have to build on the local jurisprudence, Mr. President. Mr. President, we have heard comments in respect to other Caribbean jurisdictions and other jurisdictions beyond the Caribbean that have gone this particular route and have allowed for appeals, right across the Commonwealth, in fact. And I just want to say also that the process used by these bills is not in contradiction to our Constitution. Because when you look at what is contained in the Charter of Rights of the Jamaica Constitution, and in particular, Section 16(9) of the Charter of Rights, it says that no person who shows that he has been tried by any competent court for a criminal offense and either convicted or acquitted shall again be tried for that offense or for any criminal offense of which he could have been convicted at the trial. For that offense, save upon the order of a superior court. So the process of going to the Court of Appeal is encompassed, captured in the bills that we have, and is consistent with what is contained in the Charter of Rights. Mr. President, to the prosecutors, I have this to say. These bills are bringing about a monumental shift from what has existed for a very long time. And in my research, came across a comment that was contained in the prosecution policy of the Commonwealth of Australia, in which there was a guide that said, the right of appeal must be exercised with appropriate restraint. It exists in that country, but it must be exercised with appropriate restraint. And when you look at what is contained in this bill, there has to be consent of the Director of Public Prosecutions. So although there are prosecutors that have been identified and named across different agencies, they just cannot get up and go and say, I want to appeal. They are constrained because they will have to obtain the consent of the Director of Public Prosecutions. Well, Mr. President, the right being proposed in the bills must never be used by an overzealous prosecutor or one burdened by his or her own ego or feelings to appeal or to seek a retrial of a matter where the decision of the judge terminated the matter in favor of the accused. It is, if you listen, Senator Brown, listen. Any decision to use the provisions in this bill, if passed into law, must be made after objective and judicious assessment of the provisions contained in the bill and all the circumstances of the case. And I want to suggest that it has been written in policies that have come out of the Office of the Director of Public Prosecution. And I want to commend the present Director of Public Prosecution because she has been open to the public compared to other directors that we have had in the past. She has presented for public consumption and availability, because they are on the internet, policies as to how that office operates. And attorneys have used what has been written there against prosecutors in the court as to how they should go about prosecuting matters and to maintain themselves as true ministers of justice. And I want to say, Senator Scott Matley, that not only they are ministers of justice, but those on the defense, at the defense private bar, they are also ministers of justice. Right? So it is not that they are to be and we are not to be. All of us must be. So, but Mr. President, a policy can be written as to how this right of appeal will be conducted, assessed, and determined. And I want to suggest that if prosecutors go beyond that and seek to abuse what is being allowed to them by this legislation, that it must be viewed as prosecutorial misconduct and the appropriate sanctions can be applied. Mr. President, I'm just making all aware that these bills do not impact upon verdicts of acquittal that are made by juries. This bill does not impact upon verdicts of acquittal made by a jury once you cannot determine that there is any administration of justice offense. Administration of justice offense. All right? So, and I raise it for this reason. Because we are presently in a pandemic. And in the pandemic, we have not been having jury trials. There has been encouragement from high offices, from judges and others, that persons can agree to judge alone. Persons can agree to judge alone. We have been told that there are 4 courts across Jamaica that can be retrofitted to accommodate jury trials, having regard to the circumstances in which we presently exist. And that is why I say that the whole process of using it must be, you must be restrained in it, you must be careful in how you seek to use it, and do not abuse it. Because what you will find, Mr. President, is that every accused was the opportunity of saying, well, I'm going to wait on a jury, you know, and matters drag on and on and on. So we must be cautious in its use. Unless, again, the state is prepared to make a massive expenditure in respect to expanding courtrooms, expanding facilities, and so forth. Mr. President, the concern that was raised about sentencing by my friend, when I look at what was presented in the draft by Mark Golding, as he then was Minister of Justice, the wording is the same. That's what he intended to bring to Parliament, you know. There's no change in it. It says here. Yes. It says here, Mr. President, subject to subsection 2, the Court of Appeal shall allow an appeal against sentence if the court is satisfied that the sentence imposed is manifestly inadequate or unduly lenient, taking into account any sentencing guidelines applicable, etc., etc. I look in the bill that is before us, the wording is the same. It's the same words that were being used. Same words being used then, same words being used now. But what it is saying, Mr. President, is that these are one of the constraints that you have, because in order for you to be able to appeal and be successful in the appeal, it is not just because you disagree with the sentence as a prosecutor. It has to be to the level that the sentence is manifestly inadequate or unduly lenient, and when you take into account the sentencing guidelines. So if you look on the sentencing guidelines and they are applied, and you are manifestly, pardon me? It does. It does. If you look on page 4 of the appellate bill, in what would be B on that page, the sentence imposed is manifestly inadequate or unduly lenient. Or, to Mr. President, the Supreme Court, well, sorry, Senator Bunting, the original draft had it. Sorry. No. Hold a second. And in respect to B1, Senator, we have said the Supreme Court did not have the power to impose the sentence. So there are constraints written within the bill. If we read it carefully, it just takes a little bit of reading, a little bit of understanding that within the bill itself, there are constraints that are written into it. It is just at large for the prosecutor to get up and say, well, you know, I don't agree with the sentence, so let me go and move along and seek to appeal, and we're going to get those things done. In respect to also what was commented on, in respect to the administration of justice offense, it says save and accept. So if there would have been a conviction, save and accept the interference. That is what the Court of Appeal is going to look at, you know. Because you ask, how would it be proved, etc., and you read a particular section. If the evidence is one that you would determine would have led to a conviction, but there was a return of a verdict that would indicate person acquitted, and there are these evidence presented to show that there was some interference in the process, that is when you have that overturned. That in itself is a constraint when you look at how it is written Mr. President. So it is not just at large. Mr. President, in order to deal with this particular issue, I raise these things for our consideration, for the consideration of the Ministry of Justice in how it deals with the situations that exist presently in our courts. Jury rooms, when you look at jurors coming into a court, persons who will form the jury pool can be selected as jurors. They are judges of fact, but coming through the same door with the person who is on bail. They're coming through the same door with the witness. They sit in the same environment before they are called to go into the courtroom for the possibility of being selected as a juror. And so these are things that we have to look at beyond the bill. We have to look at them beyond the bill in ensuring that we put things in place to also, as a state, prevent the possibility of administration of justice offenses taking place. So the jurors should be given improved circumstances in respect to how they are kept separate from witnesses and even the accused. Questions that will also arise, Mr. President, that we have to look at in implementing this particular bill is that should jurors be sequestered, and at what point in time? From the commencement of the trial, or at the point in time when they move into trying to determine the issue of guilt or innocence? Mr. President, I raised it some time ago when I just came into this chamber in 2016. Should jurors be identified by name in the court? Because with the technologies that exist currently, persons can just go Google and you find out information in relation to jurors. We can move away from that and to have them be issued with numbers. But yes, to determine whether it is jurors of your peers, that occupation is given.
Senator, you need to yield. Thank you. Mr. President, your watch seems to have stopped, but the senator's time having expired, and you need, I think, and therefore ask that his time for speaking be extended by 10 minutes.
We noted that. The question is that the member's time be extended by 10 minutes. Those in favor? Against?
Thank you, Senator Bunting. And I won't need so much time. In fact, I did not even believe that I would have gone beyond the time. But also in respect to witness rooms, again, witnesses come and sit in the same environment and are not protected. So I just throw out those things for the Ministry of Justice to look at in respect to when this bill is going to be passed and to be implemented. In respect to the issue of legal aid contained in the bill, something that I commend, that this particular facility is also now going to be extended to allow for persons to be given legal aid when situations arise where appeals are being pursued. And the issue of fees is something that has been commented on. I won't go any further, but that is just a sore point right across the legal profession as well, Mr. President, that you have accused who should be afforded, in respect to some things, the ability to be resourced. You may need a handwriting expert. I don't know, I've never seen it extended as far as that, in providing certain other things to accused persons, so the issue of having a fair trial can be done. So, Mr. President, with those with those comments and suggestions, the bill, moving from what it was to where it presently is something that I can support, and I do give my support to it, and I trust that we will have it implemented because justice has two sides. Thank you, Mr. President.
Outstanding.
Thank you, Senator Sinclair. Senator Bunting.
Thank you, Mr. President. Jamaica has suffered from a high violent crime rate for a long time. And as I pointed out in my State of the Nation debate contribution, the rate of murders and shootings are up this year, and in fact have been up every year for the 6 years since this administration was elected in 2016, relative to any year of the previous administration. And so I'm not surprised that the leader of government business would refer to the 5-year-old shot and killed by a criminal's bullet in her bedroom this week. But she didn't have to stop there, because also this week we had the case of the teacher abducted from the parking lot, throat slashed and dumped out of the car like garbage. We also had the case in Montego Bay, Senator Sinclair, where 10 persons were shot in one incident. Believe broad daylight, 3 dead so far. We had a case of butchers murdered going to back the cows. We had 1 48-hour period, Senator Brown, where you highlighted that there were 15 murders in 48 hours.
Wow.
So, Mr. President, I understand why the government is desperate for some measure to stem this nightmare of violence, particularly as they had campaigned on having the solution. But we've also seen that this administration's first mistaken instinct, is to curtail people's rights. We saw it with the state of emergency. We see it with the heavy-handed enforcement of the DRMA regulations which allows the Prime Minister to now criminalize persons to create criminal offenses by himself. And we are again seeing it in terms of the over-concentration of power in the office of the DPP being facilitated by these bills. The truth is, however, Mr. President, is that the government is looking at the wrong places for solutions. Studies all over the world confirm, and my colleague Senator Motley referred to this, studies all over the world confirm that it is not the harshness of punishment or the prosecutorial right to appeal that will be the main deterrent to crime, but rather the certainty of conviction. And before you get conviction, you have to identify and arrest the criminals. We have seen since the start of this year, the clear-up rate for murder has hovered in the 30%. On average, 1 in 3. And that is just in terms of identifying somebody to arrest and charge. So at that stage is 1 in 3. And we have seen from the statistics provided that, again, it's about the same or less in terms of the rate of conviction once it comes to the Supreme Court. So where we really need to pay attention to is ensuring that we identify the perpetrators through better intelligence, through better investigation, and build cases that will put them away. Mr. President, when we examine data provided originally by the statistician of the Supreme Court, but included in the Jamaica Bar Association's preliminary submissions on the issue of rights of appeal for prosecution, it shows that the conviction rate after a trial for the year 2020 was 31%. And this is not of murder specifically, but trials in the Supreme Court. The majority of these convictions arose from instances where the accused person pleaded guilty. And I'm here quoting from their submission. There is no data to suggest that these not guilty verdicts were as a result of any error of law or an administration of justice offense. The likelihood is that the investigations were poorly done or insufficient, cogent, credible evidence was produced. And they close that point with the sentence, there is no evidence that it is our judges who are the root cause for these low rates of conviction. Mr. President, when you look at the spreadsheet and you use, maybe let's not use 2020 because that was a COVID year, so it might be not a typical year. Let us look at 2019. The number of cases disposed of in a home circuit court, 309. Guilty plea, 112. Guilty verdict, 33. So most of the guilty cases arise from the plea facilitated by the plea bargaining legislation, which is what was intended and what we had expected. Not guilty, formal verdict, 6. Not guilty discharge, 15. No evidence offered, 92.
No evidence offered by prosecution?
No evidence offered, 92. Nolle prosequi, 37. So and it's similar when you look at the conviction versus acquittal in the High Court Division of the Gun Court for 2019. 508 cases disposed of, 70 guilty pleas, 56 guilty verdicts, no evidence offered, discharge 135, no further evidence offered, discharge 51, nolle 23. So we have not seen where the statistics support the justification. And as my colleague said earlier, we are at risk of trampling on the separation of powers, which our Constitution, our system of government contemplates, where we're going into the judicial discretion area. Mr. President, these bills make fundamental changes to our system of justice. Senator Sinclair said monumental. They expand the right of prosecutorial appeal well beyond the rights given in other jurisdictions. And without the safeguards, they are potentially oppressive to the rights of the accused. Why was there such a rush to pass these bills now? They've been mooted for at least 8 years. Why were these bills not, as Senator Scott Motley said, referred to a joint select committee to allow interested parties to give public reasons, not in a private conversation, to give public reasons for or against the changes being proposed to these bills? It would have been good if the minister had shared the JAMBAR submission, the Jamaica Bar Association submission, with all of us.
24 pages.
Including downstairs, including the other.
Included in the House. It would have been good if the public saw these arguments and the public saw their democracy working,
Yes.
as would be allowed in. Now, Senator Sinclair was right in one small area. Yes, the drafting instructions were issued by cabinet. The cabinet that was in office between 2012 and February 2016. The drafting instructions. No draft bill came back to that cabinet. What? No draft bill came back to that cabinet.
No. Stop. Repeat.
I'm saying drafting instructions were issued. But as you know, the processes, or those of us who sat in cabinet know, that a draft bill comes back from the Office of the Parliamentary Counsel. That goes to the Legislative Committee of Cabinet. And after that, it comes to Cabinet before coming back to Parliament. So I don't know what document he's talking about, but it's obviously an internal document of the Ministry or the Ministry of Justice or the Parliamentary Council. And he was disingenuous at this to suggest that that document was from then Minister of Justice Golding. Disingenuous at best.
To say the least.
I bet it have no signature on it. No signature on it.
You should share it with us. Mr. President, no one would argue against giving the prosecution the right to appeal for what is called an administration of justice offense. The leader of the opposition in the debate in the lower house said it might have been more useful to call it an obstruction of justice offense, such as was alleged in the Vibes Cartel case.
Yes.
An incident with which you would be very familiar, Mr. President. That was an allegation of jury tampering. That was the position that then Minister of Justice Golding was advancing. That was the purpose. And he knows that.
Mischievous.
But the approach to the passage of these bills and what is contained in these bills raise a whole set of concerns. First of all, by bypassing the usual wide consultative process of a joint select committee, when there is no urgency,
Second needs.
what that does is diminish the quality of our participative democracy. It diminishes the quality. The second concern, as I mentioned earlier, it over-concentrates powers in the DPP. And that is always, when you're concerned about a creeping authoritarianism, which we've seen elsewhere, this is one of the things that alarm us. You're saying it's a galloping authoritarianism. But it's not only concentrating that power in the executive, but it is also taking away some of the power of the judiciary.
Yeah.
That is very disturbing.
Very dangerous.
At least it is attempting to do that. And the third major concern is that, again, it goes back to my State of the Nation address, Senator Webby. This threatens to deepen the inequalities that already exist in the society by virtue of the lack of resources of poor defendants who are going to be further burdened, even if they can survive, even by the generosity of attorneys taking cases pro bono. There will be a point at which goodwill and resources run out, and a prosecution can just keep them in the system year after year after year. And you know, the reason the leader of government business raised the 5-year-old case, it's a sort of a, what in America they would call a dog whistle, to raise the specter that, you know, this is just to deal with those vicious, dog-hearted criminals.
But let us get the numbers.
But I want to remind you, and we heard 2 instances mentioned in the debate already, but I want to remind you that some of those victims of the unfair, unjust, and even abusive treatment by the prosecutorial system don't fall into that category at all.
So true.
We had one just this week. We had the story of Detective Constable Alicia Jones, freed of a murder charge after 11 years. Just imagine, 11 years her career is put on hold. Her father died without seeing her acquitted.
Yes.
Died of a broken heart.
How can she function normally after that?
And then you want to say, achieving acquitted by the court. You want to appeal after 10 years?
Under this legislation, her trial could be, her acquittal could be appealed. She was acquitted ultimately because of the ballistic evidence, the scientific evidence, which could not confirm that the bullet was fired from her weapon. The round didn't come from her pistol. But, Mr. President, there is one that you are even more intimately familiar with. There's a case of Dwayne Lewis.
Yes.
I recall when I was minister, this case had already been going on for 8 years.
That's all that soccer case.
And 50 court appearances. This was back in 2014. Yeah. Already, the accused had been incarcerated and taken to court 50 different times. And today, this morning, I learned from the president that the case is still not resolved.
And perhaps since the case is still before the court, you should not reference it. I'm just saying that since the case is presently before the court and you really know nothing about it, perhaps you should refrain from making reference to it.
I'm not getting into the particulars of the case.
You are, because you identify me as being the counsel and suggesting that I know about the case.
No,
let me put it to you this way. I would prefer if you did not make mention of the matter as it is still live and presently before the court. And as you know, I am the defense counsel in the matter. So if you would move on, I would appreciate it.
I'm just referring to what was in the media. But if you are getting sensitive...
You're not saying what is in the media because you are discussing what you and I discussed this morning. And it was not on the record.
The case, as I understand it, is still not disposed of. This is a case from 2004, 2006. But let me deal with another case that has been disposed of, and it's been raised twice here. It is the Irwin rape case. In this case, the prosecution, in the face of the DNA evidence to the contrary, and I pause here to recognize that in his presentation, Minister Samuda spoke to the dramatic improvement in convictions of rape cases since I piloted the DNA legislation in this House. And the conviction rate has increased tremendously. Again, scientific evidence. But in the Irwin rape case, contrary to the DNA evidence, the prosecution maintained opposition to bail and insisted on going to trial with a case that the judge ultimately described as, and I quote, porous and brittle. Yeah. Porous and brittle. Both brothers were acquitted. And Senator Sinclair, in court, the two eyewitnesses who were unable to positively identify, the two eyewitnesses were unable to positively identify the men. So it's not that there was a conflicting set of pieces of evidence. The eyewitnesses couldn't positively identify, and the DNA had placed them not at the scene. So what this just demonstrates, one, is that witness evidence is as unreliable as Senator Sinclair's version of events, and that we need to rely more on forensic scientific evidence in our prosecution. And Mr. President, there are many other examples where investigators manufactured evidence or prosecutions went forward on inadequate evidence. And in case you think all my examples only affect those who are poor or working class, there are cases that show how even middle-class professionals are at serious risk. And Senator Scott Motley referred to one this morning. Prosecution was initiated by a company against senior executives. The resident magistrate found there was no fraud committed.
Mr. President, the time being 1:20, might the Senate be permitted to sit beyond 1:30 to complete the business of the day?
Members would have heard the question. Those in favor? Aye. Against? Senator Bunting, continue, please.
The resident magistrate found in this case there was no fraud committed or even intention to commit a fraud, and acquitted the accused. The complainant did not agree with the verdict and sought to set aside the acquittal and have a retrial. In addition, well, let me say every court held that the autrefois acquit would apply. Double jeopardy would apply. But it nevertheless went through 5 stages because money was no problem for the complainant. One defendant died without enjoying his acquittal. Another has struggled to recover her good name and restore her good name. The process ended in the Privy Council 4 years after acquittal by the resident magistrate. I use this last example, Mr. President, to show that while we may think we can exempt ourselves and our friends and cronies, for example, in the DRMA regulations, we should not sit here comfortably in this Senate, in this Parliament, in this sty of contentment, so to speak, thinking that we will pass these laws, but certainly they will never apply unfavorable to ourselves, our children, or our family members. And they will never have to face the dangers of these amendments that we're passing today. What the example that Senator Scott Motley raised earlier shows that it only takes a powerful person with a fiat to prosecute to make the life of even uptown, Upper St. Andrew professionals a living hell.
Can lead to persecution. Can lead to persecution instead of prosecution.
That's correct. So just some specific comments on the bill, and I would pause here and say that the original draft of the bill, what we have before us, has improved versus the original draft. And
Was tabled in the House.
the original draft that, or rather not the original draft, the original bill that was tabled in the House of Representatives. And most of that improvement was facilitated by suggestions made by the leader of the opposition on this bill. So it is true that what we have here is an improvement on what was originally tabled. The whole removal of the term of mixed law and facts, which was in the original, that came from the leader of the opposition. And we are happy that any right of appeal grounded in challenging a fact has been removed. Mr. President, we also are concerned that the evidence, the so-called fresh evidence, must meet a high bar. Factors such as it is evidence that it was not available at the trial, it must be relevant to the issue, must be credible. After considering whether there might have been a reasonable doubt in the minds of the jury as to the guilt of the appellant if that evidence had been given at the trial. This is the standard, and we believe that it should be a high standard, whether for the appeal by the defendant or the prosecution. And to come back to the issue of the cost, because this is one of the areas that we feel, one of the risks of this bill of being oppressive. The Bar Association in their submission made a point that the Gun Court Act should be amended to allow appeal to the highest court in the land unconditionally, save for the constitutional provisions for same. If the prosecution has a right of appeal from the gun court, an accused must have a further right of appeal to the Judicial Committee of the Privy Council. And the Legal Aid Act and regulations needs to be amended to remove the accepted offenses. For example, under the Dangerous Drugs Act. Because the burden that is being placed here on an average citizen would mean that an impecunious citizen would be disadvantaged in any event, but especially by this extended right of appeal for the prosecution. There is an issue, Mr. President, about legal certainty. And Senator Sinclair spoke to a number of sections on page 7 of the bill, 9A, where an appeal is brought in any case where leave to appeal is not required. The court shall hear the appeal within 12 months. after the date on which the appeal is brought. And if court orders a retrial of the case, the retrial shall commence within 6 months. And there is another section on page 16 where 16 subsection 10, where a person is to be retried pursuant to an order made under this section, the trial court shall fix a date for the retrial, being a date falling not more than 2 months after the date of the order. But what's not clear to me, and perhaps the leader can in our closing clear up, what happens if these cases don't proceed to retrial within these time frames set out? What happens? Because there's a principle of legal certainty. Some other attorneys I've heard refer to it as a guarantee of acquittal. In the UK, for example, under section 58 of their Criminal Justice Act, it speaks to the, let me see if I printed the relevant page here. Section 58.8. The prosecution may not inform the court in accordance with subsection 4, and that is that they're going to appeal the ruling, unless at or before that time it informs the court that it agrees that in respect of the offense which is the subject of the appeal, the defendant in relation to that offense should be acquitted of the offense if either of the following conditions is fulfilled. A, that leave to appeal to the Court of Appeal is not obtained, and B, that the appeal is abandoned before it is determined by the Court of Appeal. And I think the idea of that is not to leave an accused in a sort of limbo indefinitely, where the case is neither moving one way or the other. And I'm not sure, and this is why I would like the minister to clarify what happens if in either of those cases the retrial doesn't proceed within the time stipulated. Does that bring closure and certainty of acquittal, or what happens?
I thought that he was ending in any event.
No, I think he was asking
I'm
a
about
question.
to wrap.
He was asking a question with what has been referred to as a crescendo.
Do you need more than 10 minutes?
No, that's fine.
The speaker's time having expired, might he be granted a further 10 minutes to complete his presentation?
Members would have heard the question. Those in favor? Against? Senator Bunting, continue, please.
Thank you, Mr. President. So, Mr. President, and I'm wrapping up now. The risk of these bills is that they will overburden an already under-resourced appeal system. They will overburden an under-resourced appeal system. They will also perhaps overburden the jury system, as many more defendants may seek for a jury trial because at least their acquittal would be final in that circumstance. And the final risk is that it can oppress the rights of the accused. It financially oppresses them and further oppresses them by extending even longer the process, the length of the process during which their lives would be on hold, as we saw in the case of Woman Constable Alicia Jones. Thank you very much, Mr. President.
Thank you very much, Senator Bunting. Senator Campbell, as in Lex.
Thank you, Mr. President. Mr. President, I shan't detain you very long. I know that there are some gastronomical delights which are awaiting some of us who take the lower floor.
No, man, I hear gastronomical. Those delights are awaiting some birthday members here, so.
Oh, that even will give me reason not to detain you any further for very long, Mr. President. Mr. President, a significant number of the arguments which should really guide us in these proceedings have already been settled. And I'd just like to deal with very quickly what it is that this bill essentially sets out to do. And it appears that what we were attempting to do was to place on trial the entire criminal justice system. This bill, or the bills before us, essentially seeks to reorder certain established norms. And that is what our law is about, reordering society and anticipating and meeting challenges which we are likely to encounter as the society develops. In this particular case, we're changing a long-established principle that the Crown will not be allowed to appeal. And there was good reason at that time for us to have that particular provision in place. But are we to say to ourselves that for 60, 70 years on, when the society has moved on and things have changed, that we will keep it, notwithstanding the frailties, the weaknesses which have been shown up? We're here saying that we want the entire trial process to be fair. Can we say that the trial process is fair when we allow a system to continue where you can hide evidence or you threaten potential witnesses so that they fail to appear before the tribunal, and you still go ahead and deem that process fair? So, in circumstances where the evidence is not brought before the court, the accused has to be discharged. But then the victim of that particular crime goes off and he feels hard done by, and he says the system is not working for him. But then he discovers that there is evidence there which points to unfairness in the system. And he says to the powers that be, listen, this needs to go back before the court for the entire process to be treated as fair. And it's in those circumstances that we're saying that the prosecution should have a right. And let me very clearly say that we are not attempting to do anything that the Constitution has not made provisions for. The Constitution makes provision for this very thing that we are dealing with to take place. Are we saying that it is fair to the society when a judge determines that an accused person, properly convicted, gets 5 years less than what is fair in the circumstances? There are guidelines for judges to use in determining sentence. And if by chance a judge errs, is it fair to the system that the accused should benefit? He shouldn't. There's absolutely no provision for the state to call on the machinery that it has put in place and say, well, listen, this is not fair. And it's in those circumstances that we are saying that the prosecution ought to have the right to appeal. It is not a carte blanche right for the prosecution to just widely go, and in several provisions there. But we are looking at a system which, to this date, remains unfair to the entire society. And who represents the entire society at a trial, at a criminal trial, is the Department of Public Prosecutions, in whatever form you take it. So we should, in bringing fairness to the proceedings, say that the rights to which an accused man is entitled. I heard Senator Scott Motley saying that we call into question the integrity of the system when we allow the prosecution to appeal the sentencings. But isn't that the very thing that accused people have been able to do for umpteen years? They have been calling. Are you saying that when the accused man appeals and says that my sentence is manifestly excessive, so if you're saying that when if the prosecution is allowed to do it, it calls into question the integrity. By reason of logic, if when the accused does it, when he says, "Oh, judge, you've made an error in relation to my sentencing," it would amount to the same thing, isn't it? Well, if what's good for the goose in trying to determine what is fair, it ought to be balanced. If the accused man is entitled to say, but that judge, you have used the wrong methodology at arriving at my sentence, and I am asking the Court of Appeal to have a review, to look at it and say whether it is fair in the circumstances. I believe that similarly, the prosecution, if it deems on behalf of the entire society, it must be able to go to that appellate court and say to you have used the wrong approach in arriving at the sentencing in relation to Mr. President, we have circumstances you see, once we have this, no longer will the accused be able to say that the trial process is unfair when he himself has caused the process itself to become unfair. If he uses, and it is discovered that he has used subterfuge, whatever it is, threats to the system, and it is discovered, in those circumstances, we say the process is unfair. And we say in those circumstances, the Department of Public Prosecution ought to, quite properly, bring the matter before the appellate court and to have it determined there. I think generally, Mr. President, this is about fairness, and the society has moved on. We are at a point where all kinds of things being done to interfere with the process and to make it not as fair and just as we would like it. So this is an attempt to bring some balance into the process. And I'd urge my colleagues to support, as I quite rightly do, this process, the passage of these two bills. Thank you, Mr. President.
Thank you, Senator Campbell. Mr. The lectern.
No.
Okay, I'm sorry. Senator Brown. The lectern I was at. No, he said he doesn't need it. It's okay. Eh?
No. Cover is. Mr. President.
Mr. Orderly. He doesn't need the lectern, you know.
Yeah.
Brown.
I thank Senator Campbell for holding brief for Senator Bryan, because that strike me, that's what he was doing. President, I rise in opposition to this bill, to these bills. I oppose them, whichever signature would appear on them. In the past, when I sat on that side, I've disagreed and opposed positions adopted by the government. So I oppose to these bills because essentially we're trying to pour new wine into old wine skins. And it's not going to hold, not going to work. The old wine skins are going to burst. Over time, successive governments have sought to reduce the rights of our citizens accused and who, under our jurisprudence, remain innocent until or unless proven otherwise. So we saw the Suppression of Crime Act and the Gun Court Act, which meant that in some cases, their case is no longer tried in open court. And in fact, just recently, some visitors were found with illegal guns and ammunition. And we were told that the matter was in the gun court, so we can't comment on it, including the fine, which Some say, some were able to compare that fine for illegal possession of firearm with the excessive fine of 200,000 for not wearing a mask. So we see the suppression of crime act. We see successive government moving legislation to remove the unanimity of jurors and to introduce majority jury decision. And like in the United States where the jury has to be unanimous. I saw that as a reduction and I opposed it. We see also the introduction of paper statements. So that if somebody is not available, paper statement can be used, can be challenged, can be cross-examined on. So we whittle away the rights of our citizens. And some would say, what has been the result? Has there been a reduction in crime? The way the minister spoke, you'd believe that with this new bill. The criminals who kill Den Salmon, that 5-year-old girl, is going to somehow be caught and sentenced, so that we're not seeing a reduction in crime because we take away the rights of the accused. Far from that. We have seen an increase, an exponential increase, certainly over 1974 to now, of crimes. So these measures are not solving the crime problem. It's not reducing criminality. So to argue that we're doing this is like the argument Senator Sinclair, which was advanced, that if we just pass the Road Traffic Act, the carnage on the road would stop. The disorder would disappear. The truth is, we passed the Road Traffic Act, but today, it's not effective. It's not implemented because there's no regulations. And so we come to this bill, again, just like the Protective Disclosure Act, passed in the House, but of very little use. And we have heard, oh, other people do it. And I'd have hoped, President, that would have been told what has been the experience with these appeals in other jurisdictions and why, therefore, we should adopt them. But I don't even think there's such data available or was consulted. And so we don't know. We're going blindly into something that is going to take away the rights of our citizens. And last week, I mentioned the book by Kipling Douglas, that former RM in Hanover, where he said, as one of the chapters about a lawyer jumping up when the case went against him because it said, got you. Now I can go to appeal. It sounds to me like that's what we're doing. And that lawyer said so because the complainant couldn't manage, didn't have the strength of pocket, didn't have the money. Just think, as Senator Scott Motley said, at Cathy Barber had to face the might of the ATL group when she was acquitted by the court. You think she could follow that appeal of her acquittal through the Court of Appeal up to the Privy Council? And that was not a poor person. That was not criminal. That was an upstanding middle-class person. The daughter of a former governor. Was it? former financial secretary. So if she couldn't manage that, think about the man from Flankers, or Havana Heights, or Augusttown, or Tavern, or Standpipe. Legally will not do it when those persons are carried through. And let me remind you of a case, President. We may disagree. The case of Current Spencer. It took 7 years with a lot of gymnastics from the Director of Public Prosecution Office. He was acquitted. He didn't like the acquittal.
Mr. President, I think that I am yes, on a point of order. The statement on gymnastics from the Director of Public Prosecution's Office, I think is unworthy of my friend without any proper basis, and it should be withdrawn. It's not proper for us to impute motive to a public officer without any basis. I don't think it is appropriate. Gymnastics, I am objecting to.
All right, Ronnie, I withdraw gymnastics.
Thank you very
much. But maneuvers through the court system that extended the period of time before that case was resolved. 7 years. And then you ask, now, the Parliament must give you the right to appeal a case that lasted 7 years? And I say no to that. I'm opposed to that. Not because of who it was. Let's take the case, and the case of Dwayne Lewis was mentioned. I won't go to that because they said that's not resolved. But take the case of Christopher Dixon, accused of murder in Safa, the fortune teller. 8 years. I could go on my phone now, as you did, and quote the attorney by the name of Tom Tavares Finson. Because you are the president now, I can't answer the president. And the things he said about, I hear him laughing in the office now. The things he said about the prosecutorial system. No, I'm going to quote, I'm going to save time. But it's there. Right? In other words, after 8 years of an acquittal, we must give the prosecution the right to appeal that case. And I ask you the question, Senator Campbell, how many appeals will they have? 3? No. We're getting it wrong. Question I'm asking, how many times will they be able to appeal a case? So they get a retrial and acquittal take place. Can they appeal that too? We must put some restriction on. We must put restriction on that. Because there must be some certainty to the citizen's life. There must be some certainty to the citizen's life. And so, when I say what we're doing is putting new wine into old wineskin, the Court of Appeal is now throwing out cases because of an absence of transcript. I raised it last week, you know. You're putting in now a sexual harassment tribunal, larger than the Court of Appeal. But I ask the question, where are you going to get the people to record and keep a record of the proceedings? Just think of our parliamentary staff, overworked, underpaid. You think this group, these people with their skills are out there dime a dozen ready to be? It's a selective group. It's an exclusive group. It's an underpaid group, an overworked group. And I speak of our answered writers. I speak of those at the courts. I speak of those at the tribunal. So we're going to put in a system now for more appeals, for transcript to be ready within, so that you can have it in 12 months. Points you are making, you know, President, about are we ready for this? Are we putting the cart before the donkey? Or are we behaving like donkeys in passing this law in the way we do it? A donkey said the word on level.
Do not disparage donkey.
Donkey said the word on level, and that is correct. So we're presenting a situation here. No. Where the infrastructure for what we're doing, now is not proper, not good, rickety, weak. And we're now going to be adding more to that. Are we really serious? Are we just passing this to say we pass a bill to give the right to the DPP to determine appeal against convictions, which they may not be happy with? And let us be clear, I think you said it, President. This is not about decisions of the juries, because people out there may say, yeah man, the jury make a bad decision. This is not about decisions of the juries. You can't appeal the decision of the jury. Let us be clear. That's not what these two bills are doing. They are not asking you to appeal a decision of a jury that you disagree with. So some people may say, oh yeah man, people will take bribe and so. That's not about the jury. It's the decision of the judges that is being appealed.
Senator Brown,
it's a point of order?
I'm just pointing it out to you because you make it seem as if it is just restricted to that. But if the jury, if there's an administrative of justice offense, because you are referring to something.
You bribe a juror.
Eh?
But essentially, what we're talking about is not the decision of the jury. Not the decision of the jury. If somebody is bribed or so, and that happens now, even now, it can lead to the prosecutor making a null prosecution. So that's not what we're trying to challenge. It's not the jury decision. And I say that because members of the public may believe that it is a jury decision that you're challenging. No, it's not the jury's decision. It is the judge's decision. Judge's decision on no case submission. Judge's decision on quashing an indictment. That is what is being challenged. And the question I ask myself, of our judges, are we not confident in them? Are we not confident in them? Are we not putting in place something which says, Judge, I am the prosecutor here. I feel it should go this way. And if it doesn't go that way, I know of a right to appeal. Which judge loves to see their cases being appealed? So now you're putting pressure on the judges, where we say, whatever you decide, I'm going to appeal you. So it strikes me that this is about a lack of confidence in our judges. We believe, we may disagree sometime on some of the decisions, because I disagree on the 200,000. But that is within their competence and authority for people and fine. I may disagree with it, but they have a right to do it. I may disagree with giving a gunman a couple years rather than a longer sentence. But it's the judge's right to do it. And I believe we must show that confidence in the judges. To tell me judges go and make error, yeah, that is a given. Judges make errors in summing up historically. But it's not deliberate, not malicious. And because we come from a system which says the defendant is innocent until proven guilty. And if I may quote Minister Chuck when he was at law school, it's better for a guilty man to go free, or 1,000 guilty men to go free, than one innocent man be convicted. But that was when he was at law school. Now he's minister. Now he's minister. The view changed. And so, yeah, that sounds like gymnastics. That sounds like a change, a flip over. Yeah, right? So because, I don't know, I really love to make point about it when I'm talking. But the concern I have is that we are undermining the rights of defendants. And so I can't support this bill. Fresh evidence, for example. The prosecutor can now come with fresh evidence. What if that evidence was available but they had not brought it in? The standard for fresh evidence for a defendant laid down by the Privy Council is very high, very restrictive. That doesn't seem to be the case with fresh evidence for the prosecution. So, for example, let's take a case the Privy Council dealt with, where a man was convicted, but there's evidence that the camera system not showing the person entering the bank. Let's take it the other way. What if the police had that information and didn't bring it in and the person was acquitted? Can we now then say fresh evidence arise? That don't look fair to me. It's like saying Bunting is Minister of Security and all of a sudden they discover down the road, not very far from now, Center Bunting, they discover that there are hotel records weren't really written over. Fresh evidence. So we have to be careful what we're doing. We have to be careful what we're doing. So, on the basis of what has been said, there ought to be certainty. There ought to be a stop to the eroding of the rights of our people. Because, President, as I think Senator Bunting has said, it's not just a little man down there. I know of a case, for example, somebody brought a private prosecution, a former resident magistrate, against a company for failing to implement an award from the Industrial Dispute Tribunal. And a nullity was entered against the former RM pursuing her case to bring this international airline to justice. There can be abuse, is what you warn us against, President. And the best way to avoid such abuse is not to put butter at the mouth of the feline. You can say that because you may want to add why. You may want to ask me why. So I'm making a point that the best way to avoid the concerns you had of abuse is not to bring this legislation in. It's not going to solve crime. It's not going to, it opens itself to abuse. It reduces the rights existing now of our citizens. And I make this point today for you, tomorrow for me. There, but for the grace of God, goes Cathy Barber. Could have been me. Could have been me. So, I don't like this legislation. I'm opposed to it. And the room for abuse is great. Maybe not this DPP, but we never know who. Maybe the next DPP or the DPP after. And the best way to avoid that is for us to withdraw this bill, not proceed with it, and keep.
Mr. President.
Sorry.
Mr. President, just a point of
I just want to check with you, Mr. President, because it seems as if we doesn't have a quorum in the chamber, and if we don't have a quorum, we'd have to move for a suspension of the sitting because we do not have a quorum at this point in time.
All right, what we have here in respect to the standing orders as it deals with quorum, that the quorum of the Senate and of a committee of the whole Senate shall consist of 8 members besides the person presiding. And 7.2, if at any time during a sitting of the Senate, objection is validly taken by any member that there is not a quorum present, the person presiding shall direct members to be summoned, and if at the end of 5 minutes a quorum be not present, he shall adjourn the Senate without question put. So what I ask, the matter having been raised by Senator Morris, I just ask the clerk to make a check to, first of all, ascertain for me if there is a quorum present with the numbers here. Pardon me? I see. So there are sufficient members present, and so we won't have to move to standing order rule 7.2. I just ask Senator Brown to...
But, Mr. President, just in fairness to the Senator's powers of observation, at the time he raised the standing order, we did not have a quorum.
Absolutely.
I thank you, Senator Bunting. And as the rule says, that it requires me to summon, and if at the end of 5 minutes, I did not even have to go to that because I'm told that way under the 5 minutes, that we have a quorum present, I then ask Senator Brown to continue his presentation. Thank you.
I'm wrapping up to President, but I'm glad that it doesn't matter whether they're here or not, you know, because the people of Jamaica hearing what I'm saying. So let me continue. Senator Campbell L. raised the issue of the prosecution should be able to challenge sentences. Maybe what we should do is do what the United States do. They have a victim assessment. They have a section, their hearing and sentencing allow for victims and the prosecution to say, this is what we think the sentence should be. Not after, but before sentencing. And if we do that, the prosecution is what we think. And don't forget, we have plea bargain. The prosecution may suggest something, and the crown and the judge says, having regard to everything and not going with your recommendation. Leave it to the judges. Leave it to the judges. Let not this parliament try to go back to where we were in the past, where we set mandatory